I think I'll pass on to Remy now to facilitate our discussion.
Okay, thank you, Idina, and thank you very much to our last speakers, Michael and Tal, Lee, Jonathan, and Vasilis. Thank you very much for the summaries of your video. Now we are going to open it up for discussion. So we are going to allow the audience to ask any question they want to for any of the 5 speakers that just spoke now. So any question for our speakers? You can indicate either by raising your hand virtually or physically.
I think Elaine has a question.
Oh yeah, Elaine?
Yes, hi, Lee. Thanks for what you've said. I was curious that you mentioned about kind of methods of securing legitimacy and preventing fraud, and you know, of course, to add to that, based on the last presentation, I'd also sort of talk about, you know, identity verification of the living in general is becoming an issue, and sort of you know, sort of determining whether somebody is sort of still alive or dead, or is just kind of like hacked into a dead person's persona for the reasons of defrauding an estate, I think is a really imminent sort of problematic issue. Do you have any ideas or thoughts, anyone in the room really, about methods? I realize that we might not be developers or technologists here, of securing legitimacy and preventing fraud for those people who, you know, an estate might designate like a digital executor type person, like similar to maybe Rufata type stuff in the US. I'm just curious about how that could be, ways that could, people envision that could be done.
So for my part, there are 2 aspects to what you're asking. So the first one is technological, and as is it Vasilis? I don't know how to say your name. As he was saying, there is lots of work being done to secure accounts these days, and as far as I can see, the main problem with security in accounts now is largely human. People get emails that outrage them, and they immediately click on links and open themselves up to fraud. The other one is a matter of legal precision. So when somebody dies, let's talk about death. There is information out there that they have disseminated or received, or something that is on the computer of somebody that's not them. So let's say it's on Facebook's computer. So that information, according to my understanding of English law, is that information belongs to Facebook, because there's no tangible thing that exists. It's just signals, electronic signals on hardware, and that hardware belongs to Facebook. The things that do belong to the deceased are things like copyright, or if he has crypto assets, that's also signals that you know are on a computer, or thousands of computers. But you can in some way, and this is one of the challenges today, which is so exciting, I think, you have to find a way to make tangible something like a Bitcoin, which is not tangible at all. And you have to work out how to give it some personality so that you can let it be stolen and get it back. But to your question, sorry, I went off on a tangent. That's my interest. To your question, the information that somebody has left on Facebook's computer, if you can, let's say on my last suggestion, if you can get a statute that says the personal representative has a right to use the username and password without any criminal liability and without any breach of contract between him as personal representative and Facebook, then he has certain duties to the deceased because he's a personal representative, but those are largely in relation to property. So he has a duty of loyalty. That's the basic duty. He mustn't put his own interests in front of the deceased's interests, and he mustn't make a profit at the expense of the deceased. In relation to pure information that's not property, it's largely a matter of confidentiality, and so he can't give out things that, well, you need to put him in a position if it doesn't exist already, and there's some doubt about that, but he must have some kind of duty of confidentiality towards the deceased in relation to information that he gets from him. And so these are the things that need to be thought about, I think. And there, you know, there's a whole 25 other people in this room that will tell me what the duty of confidentiality towards dead people is. But you know, that's got to be made clear in the statute, that there is a duty of confidentiality for the fiduciary, and perhaps there should be some added proprietary duty that can be specified as well. Sorry, I went on so long.
No, but it strikes me that the duty of confidentiality is not just for such a person with such a role, shouldn't be just to the deceased, of course, but to whoever else's data they might encounter along the way of executing their fiduciary responsibilities, you know, that they're tasked with, you know, this should be the reason that they're there. Because of course, what's happening now is that loved ones are doing all these hacks and workarounds informally, you know, because they're forced with a choice between upholding the law, you know, contractually, and helping their loved ones. And understandably, a lot of people opt for helping their loved ones, you know, or sort of sorting things out because they're forced into that position. But I guess since one of my primary concerns is the kind of ongoing kind of rights under the contract for the users that are living users that are still signed up to that platform, yeah, it strikes me as somebody essentially acting as the deceased, as their fiduciary, that the non-disclosure, the confidentiality, or the like not acting upon information that they find in ways that are inappropriate needs to be expanded well beyond the deceased themselves to the other people that the data is connected with.
Okay.
So I hadn't actually realised, but Remy had made the point that English law is very different here, and this is one of the things that always, that I think when you are familiar with one jurisdiction, you don't necessarily know what's going on in the other. You don't necessarily think about it, and it's always very surprising, in fact. And indeed, in the paper, the draft paper that I put in, I had suggested, well, it would be absurd to suggest that a person who was wronged might lose their right of action simply because the person who wronged them died. And from the chat, I'm picking up, well, actually, that's not absurd at all. That is the position in England and Wales. Am I correct in that, Remy?
Yeah, you're correct. In England and Wales, if the disease committed a tort against a person and then died subsequently, the cause of action cannot be brought against the executor.
Okay, that's very, very interesting, because one of the consequences of the ad persona cum defuncto rule, which the courts have actually cleaved to, is the simple fact that that kind of cause of action, we wouldn't necessarily call it that, but the action does not die with the deceased, in the same way that debts do not die with the debtor when the debtor physically dies. And a party who contracted with them, for example, can still claim their patrimonial interest out of the estate of the deceased. That is true also of any patrimonial loss that was caused by the deceased during their life and indeed any non-patrimonial affront caused by the deceased during their life. They can still bring that claim, even if the person themselves has physically died. So one of the consequences is cleaved to is that point. So when I'm talking about the eadam persona cum defuncto rule, it's, I think, addressing some of the points that Elaine was raising there, because essentially it's giving the opportunity for the law to identify a person who is, if nothing else, responsible for the deceased. And in a sense, well, the duties that Lee's talking about there, I do think axiomatically go beyond the duties that you're talking about, and essentially apply. In the same way, the duties that the person had when they were alive still exist, and the executor stepping into their shoes becomes subject to the same duties. So if the concern is that the executor might publish information which is defamatory, or publish information which is confidential, or do something which might harm a third party, then the resolution to that, taking the eadam persona cum defuncto rule to its logical conclusion, the consequence of that would be that the executor is bound, just as the deceased themselves were bound, to not publish any information which would be wrong to publish, essentially because it would be defamatory, breach of confidence, or anything like that.
Yes, I agree. In the example you pointed out, if the executor published defamatory information against a third party after the death of the deceased, even though the defamation itself was made by the deceased, yeah, the executor is personally liable, not on behalf of the deceased. The action personalis doctrine you mentioned enshrined the general rule that in tort, a cause of action dies with the disease. Of course, there is an exception for contract, whereby even the House of Laws in the 70s affirmed that exception, whereby a contractual right of the disease accrued in the lifetime of the disease could be enforced by the executor. Likewise, such a right that is owing to a third party could be enforced against the deceased through the estate. But I'm not aware of any case law that justifies such post-mortem litigation in tort after the death of the deceased. But like you said, that might be true for Scots law, but not under the common law, in my opinion anyway. Sorry, I had Michael's hand all along. Michael?
Yes, I would just like to echo one of Elaine's points from a few minutes ago, which I think is important to put on the table once again. This is a field where the law collapses. There's a huge gap between the neat distinctions and practices. When someone dies, someone else typically does have access to their computers, phones, etc., and they either know the password or there is no password, and so much of this goes underneath the radar of the law. And for us, I would argue that this is, an invitation for law and society kind of studies, qualitative, quantitative, whatever, exploring the social norms, what is behind, what derives the social norms, when and where and how do they change, if they change at all, and the relationship of all of this to the neat legal categories and laws. Now, when the platforms enter the picture, yes, they are more likely to follow the law rather than social norms, but this is where the lack of transparency enters into the picture, and not enough guidance from courts because of the issues that we've discussed in the first session earlier today.
Thank you very much. Any more questions for our speakers, please? Question for our last speakers. Okay. Okay, go ahead, Lee.
Thanks very much. I just wanted to say something about what Michael just said. There are two different things that we're talking about here. So if I want to use my brother's Facebook account, it's not going to be important whether I use it or not. If I log in and we're using his username and password, it's just irrelevant. But if somebody dies, let's take an example of somebody dying and his child of 14 years old, who's a real whiz on the computer, manages to get hold of his credentials to log into his bank account and starts to spend his money by taking it out of his bank account and sending it all over the world. And that's a different thing, and that needs to be stopped. That's one of the problems here that needs to be dealt with, and maybe that's what you were talking about, Elaine, about stopping fraud with this. But that's very difficult. It's just a matter there of educating people not to allow, first of all, educating users not to let their usernames and passwords to be seen by other people, and secondly, educating executors and other personal representatives to take control of computers quickly enough so people don't have an opportunity to do this. Thank you, Remy.
Thank you very much, Lee. Any more questions? Any hand raised? Okay, if we are not having any further question, I have a question for all contributors. Hopefully it can raise a general discussion. I propose to ask the question and then maybe call names in order to make contributions. So the question is, what is the legal or policy change you would like to see happen in view of our discussion today? So what's the law and policy in this area that you would like to see happen? Perhaps call upon is Michels here? Michels and Millard. Are they here?
Yeah, we're here.
Yeah, go ahead.
Can I just add, we were mostly thinking of sort of not to go in too much detail, like the one quick and fast change or the most burning change that you would like to see.
Yeah.
Well, okay. I would like to see clarity in English law, and I can't speak for the rest of the world that's so well represented here, as to whether or not there is a property right in the file as a container for things that we all agree have property rights to them, like copyright works in photographs and documents and so on, because we think that's unclear at the moment under English law.
Thank you very much, Michel. Lucien.
I don't think Lucien is with us anymore. He probably.
Oh, I see. Felicity is here. Felicity.
I'm here. Yeah. I would agree from a practical perspective of how could I help my clients. I would agree with what's just been said about clarity as to whether property lies in these particular digital assets in English law, and if that were available, then you would be able to use the tool of conversion to get stuff back, and that's what you need. You need a tool that gives you a remedy that is the thing. I said this earlier, not damage. You don't want damages. You don't want the payment of the notional copyright license. That's no good to you. What you want is the photographs of you with your children. And I think that would be a quick fix that would really help people. And I completely understand, and I am on board with the idea of going back to first principles and looking at this differently. but that's going to take some time and going to take quite a lot of movement, quite a lot of conceptual thought, and quite a lot of movement in the law. And this would allow people that way of being able to say, I am the executor, or I am the heir to this person, therefore their property has passed to me, therefore I can enforce this existing right and way of getting hold of it. And it would avoid the problems which we said. I completely agree. I would completely understand if a client went, well, actually, I can work out my husband's password because I know his mother's maiden name and I know where he went to school, and I'm just going to log in myself. The law be damned. You know, one never tells one's clients to break the law, but you would completely understand that position.
Can I just add, we looked at copyright in some detail, trying to find a way of getting an effective remedy, and we couldn't find one. I mean, really, copyright, as Dave said earlier, I think exists to give you control over the making of copies. And if somebody makes copies without your permission, you have remedies such as getting those copies destroyed. But none of those things are what you want here. You want to get the photos back. And the fact that Apple promises to destroy them is the last thing you want. So copyright really is, we don't think, can be made fit for purpose here. And we need clarity, as Felicity just said, on the underlying property status of the file as a container for these things that we want back.
I completely agree with you, and I'm glad somebody else went through the same thought process I did, because if you serve a copyright notice on them, all they'll do is destroy it. Yeah. So you don't do it. It's an interesting way of conceptualizing photographs as well, because I don't think we think of photograph. There's something in a photograph that isn't just the paper or the digital byte, whatever you might call it. I'm not very techie enough to know, you know, the space on a hard drive, or the intangible copyright. It's not that. It's the ability to look at the face of your loved one. That is an intangible thing that may or may not, that at present perhaps does not, although it's not clear, have a property right associated to it. But it definitely has value, and there should be a way of allowing a person to not just say that has value and so you should pay me 50 quid because you used it when you shouldn't have, but to say this has value and therefore you must give it back to me.
Would the moral rights of the author be a potential barrier to the destruction?
Well, potentially, but you've got the contractual terms which the author presumably signed up to when they signed up to the iCloud. You might have some interesting questions if somebody else was the author of the photographs. You end up with some interesting questions of personal data. Could you say, can you make a subject access request and say, you've got a load of photographs that include me, give me a copy? You have questions of misuse of private information. Can you misuse my private information by using to give it to me? There's all sorts of legal routes that are interesting to think about, but none of which are straightforward and none of which have precedent, as far as I understand it, in the existing law. And it seems to me all of them would be interesting. I could run you a claim all the way up to the Supreme Court with about 7 causes of action on this. I've got a draft of it somewhere. Different ones, running all of those types of law that we've talked about. But it seems to me that in the absence of a wealthy claimant who's up for that, the easiest way would be to conceptualize this as property for these purposes. In the same way that things like carbon credits or Bitcoin or whatever, other money even, what's money, are conceptualized as property and mean that the executor can control them and can demand that the delivery up of that precise thing.
Okay, thank you very much. We are conscious of time. I don't know whether Rycroft is here. Rycroft? Okay, not here. Burkhard?
Yep. Hi. Very much agreeing with what's said before, especially by Felicity. What I would like is not so much a change in the law, but I would like some tools that make it easier, assuming that change in law is in place, to then actually effectively act on that, so that you wouldn't have to go by platform and bring all this together. Something very, very simple, intuitive, that allows, as long as people are alive, to percolate a permission or a right across these platforms, or once the administrator, the AI has taken over for them to do this. Obviously, without creating a security risk and a single point of attack, but something that, if needed, very quickly brings all these different strands of my digital afterlife together so that it can then be effectively administered.
Thank you very much, Burkhard. Next would be Michael and Tal.
So we would suggest that the law requires the platforms and applications, etc., to have a policy about this topic and apply it or introduce it to the users as they register for the service, but without the law saying anything about the specifics of this policy, to enable both differentiation between different kinds of services. And email, Dropbox, dating applications, as mentioned in the chat, and something else is not the same. Each of them has their own unique characteristics, and to enable users to make their own choice, but without pre-deciding on any default, because default rules tend to be sticky and problematic in ways that we haven't discussed today, but economists have discussed extensively. That's it.
Yep. Thank you very much. Jonathan?
Yeah, Dina, I think, actually summarized my thoughts with a tweet earlier from my contribution to the first session. She said that I was suggesting that black letter lawyers should look at the law holistically. And that would be my hope, again, that lawyers doing our part in fighting the good fight would actually try to conceptualize this area from principles. And then, speaking from the small jurisdiction whence I hail, I would quite like to see lawyers make use of the tools that are available to them now without trying to either import piecemeal solutions from other jurisdictions or rip up everything and try to start from a piecemeal remedial type solution. I think this is an area which can be dealt with, or rather it's one which in order to adequately deal with, we have to start thinking about from first principles to clarify, well, what exactly do we mean by property? What exactly do we mean by personhood? And with that neat divide in mind, we have to ask, well, where can we and should we deal with this according to any kind of institutionalized schema? So that would be my thoughts there.
Thank you, Jonathan. Vasilios?
Thank you, Remy. I think I'm a bit torn because I like Burkhard's suggestion, which is like a password manager for your data after you die, which manages all the different kind of platforms in a unique way, and a unique, like, unilateral way that you choose, or in different ways perhaps. But I also like Michael's suggestion that there should be some law sort of at least forcing platforms to have some certain policy, because I don't think Burkhard's suggestion would work as well without Michael's suggestion. And if I could add something to that, it would be, I guess, when we're talking about cyber education for young people, for example, or in general, cyber awareness for the public, I think this should include post-mortem concepts and a perception in terms of what the implications would be for our data when we die. As I said, this might be quite a taboo topic, and perhaps it might not seem relevant to young people in schools when they get their first kind of cyber education. But I think for me, as a policy kind of recommendation, it would be important to look at cyber awareness a bit more holistically, and explain to people that the implications of what they post online or what they create online might have consequences even after their death. So that would be my contribution, I guess.
Okay, thank you. Lastly, I will call on Lee. Lee.
I'm in the information as property camp. I'm not so sure that it's doubtful. I think it just hasn't been worked out properly yet. But I would agree with Felicity if this is what she was saying, is that it should be not clarified, but changed so that somebody's photograph on their phone is taken to be a piece of property and can be retrieved by the executor or or somebody else who has authority duly given to him.
Thank you very much. That's it. I think Idina, you still here?
Yeah, I think that was it in terms of the questions. We just have this final part where we ask some practical questions that are not topic related and inform of the next steps. So again, I was going to recap the whole seminar, but I think there's no need to do that because I think everyone is clear that we definitely struggle with issues such as conceptualizations, taxonomies, problems in black letter and doctrinal problems, as well as the more theoretical and other problems that the disciplines can bring in and help us clarify and work around. So I think there is a huge scope here for further and future collaborative research projects, and hopefully they will result from this event. That's something I am leaving to everyone to discuss in their own time. But what we're going to do is we aim to produce a short policy paper highlighting some of these issues and perhaps some of the recommendations after the seminar. And we're going to try and publish it in practitioners' outlets, such as some of the STEP publications that have kindly suggested we could publish with them, and maybe some other professional, but also media outlets as well. So that's one thing to expect from us. Another one is to expect recordings from the sessions and small snippets that you kindly agree could be published for most of you in pre-recordings as well. And then notes from these sessions as well that will help us inform the position paper that Holly and Marissa have kindly been taking, and they're already there. So in terms of our little sort of outputs from the session that are not necessarily academic in strict sense. Talking about academic outputs, we do have this opportunity to submit to the Modern Law Review, which is obviously not a guarantee at all. As the lawyers will know, it's a very difficult journal to get into. But we still have sort of a head start with Modern Law being interested in the topic and funding the seminar. So for lawyers who are interested in this, and I know that 3 or 4 have already expressed their interest in the email, I think we're aiming, if you would like to submit this as a sort of collective, even though they don't do special issues, and they again re-emphasize that to us, we can submit it, and we're hoping to sort of finish our paper from our side by, say, mid-September. So I'm not sure if that works for people, and if this is something of an interest for lawyers. For non-lawyers and those who will not eventually make it in the MLR, which probably will be majority of papers, knowing the standards and the MLR practices so far, we also suggest that we might that we consider perhaps a special issue of a journal. And there are various journals that we can look into, such as Technology and Regulation, Internet Policy Review, Script, or something similar. Again, open to suggestions if there is a wider interest in submitting papers. And again, perhaps the deadline for this can be a bit after September, perhaps end of year. So again, I'd just like to hear your views on this and whether there is interest in doing something along these lines. Yes.
I mean, I don't think that what I'm interested in or was interested for this event would fit into the modern law review either. But some way of getting our stuff together. And I mean, the great thing is that it came from so many perspectives and disciplines. That might make it difficult to find a good journal. I mean, I think scripted could definitely be persuaded. They are obviously totally independent as editors, and the fact that they are all our PhD students would not in any way sway them. But it would be it would nonetheless be a possible place to approach, because they might be very relaxed on that sort of law requirement if the collective impression is that of a law of law. Other question would be, I mean, journal is probably at least for some of us, journals probably are more helpful than yet another book contribution. But we could, of course, also consider to ask EUP.
Yeah, that's another option. So an edited collection, and Burkhard and I and Lillian, until very recently, are chief editors of the Future Law series. So that's also an option, an edited collection, even though I know people are, especially in the UK, sort of not reluctant to publish an edited collection given the ref requirements and everything else. So again, we're open to this suggestion as well. So I see some interest in the chat. Of course, I will follow up with an email and give some time for people to think and express their interest a bit more clearly, perhaps. Just think about it. Michael, did you want to add something?
Yeah, yes, please. Other than the publications, I would like to return to a point I made at the very beginning of this day. I think as our community, small community, but it's growing, emerges and flourishes, and obviously more will join, I think it will be nice and important if we somehow publish a statement calling on, the platforms, Facebook, Google, etc., to be transparent about much more than they are today. The obvious is how many people have been using legacy contact, over time, countries, etc. But presumably there's some other data that they withhold. And I think they are under a moral obligation of some kind to share that data, obviously anonymously, aggregate, blah, blah, blah. But, and I think, if we sort of write a letter, a small letter / petition and publish it, it will not change the world, but, it will add another bit to the public demand from them to be more accountable. Activism.
Yeah, I think that's a good idea, and I think most of us are on this page and agree with Michael that there is this need for transparency. So again, that's something that we can put out to people and ask to sign, and it's one of the small outputs of the seminar. Elaine asked if we can plug that on a research symposium later this week. So there's the research symposium going on from Wednesday until Friday, and a lot of us here are talking at the symposium. So perhaps
looks like registration might have closed, but I think that's silly because it's just on Zoom. So I bet if you tried, I think you should plead your case.
You could email Stina, but I think the keynotes are also open. I think that they're a slightly different format to the rest of the conference. So you might still also be able to get into the keynotes.
Yeah, definitely. I think the keynotes are open.
Right. So I will be seeing some of the speakers later this week. Okay, so I think what I'll do is just in terms of the publications, just reiterate the deadlines in my email and ask people for expression of interest a bit more firmly, and options that they would prefer in terms of the book versus journal for those who do not intend to submit for the MLR. For the MLR, we're hoping we'll have articles ready by mid-September if possible. And then what else did I have? I think that was pretty much it. I think it would be useful if we had the link to the symposium in the chat now. Can someone just
Give me a
please?
second. Let me see if I can find it.
Thanks, Elaine. That would be great. So expect a lot of follow-up from us in terms of the next steps. And once again, I do apologize that there's no conference dinner in any form. And I do again owe you drinks at least. And I would like to thank everyone for the wonderful seminar that I thoroughly enjoyed. And a lot of you are dear friends, and all of you are dear colleagues that I really appreciate, and whose work has influenced mine in so many ways. So thanks again for just putting in so much work and so much intellectual labor into the seminar, pre-seminar, and during the seminar and post-seminar. And thanks to the chairs who have again done some additional work. And I apologize for being a little bit improvising a little bit more than some people might have liked. And yeah, I think.
And if I may, and thank you, Adina. Without you, nothing of this would have happened.
Yay,
So,
Adina!
Thank you for all the time and effort and initiative and bringing everybody together. I'm sure everybody joins on that. I hope so. So thank you so much to you and Lillian and everybody else behind the scenes that was involved in initiating, organizing, and having this tremendously important discussion today. Thank you.
That's great. Thanks, Michael, and thanks everyone. Thanks to the team and Marissa and Holly, who are doing enormous work behind Zoom and with some of the logistics. So I hope to see everyone in different places soon, hopefully face to face, where I'll be spending some money on those drinks. And yes. Apart from that, I look forward to the special issue or the edited collection, whatever it is, and at least a couple of us getting into the MLR eventually, fingers crossed, with the papers. So again, have a lovely rest of the day. Thank you, and hope to see you all very soon.